Erlinger is all about that.
Mhm.
Because they're looking at, criminal cases where there was a factual problem in a prior as to whether it was one prior or because it was a crime spree, one prior, the defendant or the prosecutor said, oh, that's three priors, 3 burglaries in 3 days.
Right.
So that's what it was. Now, they have been grappling at the Supreme Court of the United States. How are you going to do that? And most likely it'll be the same jury would then go into the penalty phase, so they don't know about all the prior record. Okay, but they still have to find, was that 1 prior or 3? Okay. For us, the problem is they mixed it up. They said it the first time you go to court, the judge is going to know it's a prior. So they've mixed it up, but yes, it is beyond a reasonable doubt. At the same time, they call it a discovery issue. So
I think
you got to understand, though, what Erlinger's dealing with convictions. Elaine, Apprendi, they're all dealing with facts related to the prior conviction about whether they enhance. But now we're talking about the existence of a conviction. And, again, if it's a Dennis case, we have that extra fact. It gets vacated pretty much automatically, except in very rare circumstances. But, you take it that next step. Is the existence of the prior, something that has to be proven beyond a reasonable doubt?
Well, they're saying it does. I mean, they're saying right in Zingis, aren't they saying
they're not
that?
quite going that far, Bob, but you know what? They're getting very close to it. Erlinger gets right up and knocks on the door.
That to me is exactly what they're saying, that this has to be proven beyond a reasonable doubt.
It says, you're right, but you're wrong. Okay, you know what I mean?
Not the first time.
Yeah, but it says that in State versus Johnson. I don't know which State versus. No, I'm only kidding.
Look, Justice Gorsuch got right up there.
Always cite State versus Johnson, Bob. Right?
Always. You can't go wrong.
You can't go wrong. But, prosecutor must now provide the prior disposition along with the rows of data from S-152 and the Dennis summary sheet in discovery which together will be deemed proof beyond a reasonable doubt. Blah, blah, blah. So I don't know what the hell that means.
This is what I envision. All right. And John Menzel, I'm going to throw this right at you. Okay. You've kept your mouth shut. You said, my client's not saying. Prosecutor has some evidence that this is something other than a first offense. And you say, all right, Judge, let's have a hearing on that, because the state is the moving party here. They have to prove it, and they have to prove it beyond a reasonable doubt. So let's see what their evidence is. Okay. I mean, you have a hearing on that.
You got stuff to play with on both sides. Let us just
exactly.
Yeah, I mean, what's going to happen? The state's
very fine people on both sides.
They're going to present an abstract. The judge is going to say, okay, they've established the existence of a prior. Now the burden shifts to the defense to provide additional proof, affirmative evidence that it's not you. Now the burden's got to shift back to the state to disprove that.
No, now the state says it is a Zingis case or it isn't. If they say it isn't, but you say it is, you can present evidence that it is.
I'm talking about a more prosaic case. It's just not. Let's take Zingis out of the mix, or let's take Cassidy out of the mix. He has a prior offense 4 years ago or 5 years ago, whatever it is. I'm saying put the state to their proofs and let them prove it beyond a reasonable doubt.
If it's not within the time period, all they need to show is an abstract like they have been doing for time immemorial.
Right. But
if it's not within the time
period. Would you say the judge still has to believe it beyond a reasonable doubt? That's my question to you.
He has to only believe, no, because there is a limited exception. All 9 justices of the Supreme Court agreed with the idea that if there's a factual issue, it has to be determined by a judge or a jury. And then they split up. Should it be a jury? Should it be a judge? And it's kind of like Gettysburg, where the North came in from the South and the South came in from the North, because Justice Jackson was the one saying, you shouldn't give it to a jury. You're making it too hard for prosecutors. And it was Justice Thomas who said, you shouldn't even have an exception for any prior record, every prior. So, it's like, but anyway.
It really was a very interesting mix, because the so-called liberal judges seemed to be more state-oriented. And the so-called conservative judges were more defense-oriented on the question.
But everybody still agrees. And Thomas wouldn't have agreed, but the opinion of the court is, if there's no factual dispute as to the prior, nothing changes. It's a preponderance of the evidence sentencing issue for a judge, like always. So if you look at it, it's not in the time frame. It's not Zingis to begin with. Then you get into, okay, time frame, is it or isn't it, Mr. Prosecutor? If it is, have you given him the discovery? If it isn't, Mr. Defendant, do you have anything to dispute that? The day that he walked in to the inquiry by the sergeant as to what he was doing, he said, well, and they said, well, yeah, I was doing it. He goes, well, what are you going to do then? Just, well, I'll just lie. So he said, we have the records where he told the state police, I'll just lie. So the bottom line is, he's not a witness. If any one of you are a defense attorney and you find Dennis anywhere in your prior, I don't care where it is, that's a winner because you can call him. He's not coming. That tells us that generally speaking, once it's identified as Dennis, they're going to figure you're going to win. Whether if it goes on forever, they might just give it to you. Who knows? Because now in court, we're going to have the signed documents that make the prosecutor feel good about a guideline 3 motion in the interest of justice and the judge feel good. So if it's identified as Zingis, you've already got the big, pretty much a bingo. It may not be the whole night, but you've got something working for you.